Alright guys, welcome back to the channel. Today we're dealing with a sovereign citizen who simply cannot stop racking up LS. But to be fair, he's a sovereign citizen, so taking losses is basically his birthright. We've got 3 separate cases and 6 full hearings to walk through, and every one of them is a masterclass in self-inflicted disaster. Let's get into it.
We are on the record with file number 22-186783, JP Morgan Chase Bank versus Marcus Campbell, date and time for pretrial appearances.
Good morning again, Your Honor. Jim McCardle on behalf of JP Morgan Chase, P numbers 82443.
And your name, sir?
My name for the record is, I'm the authorized representative here on special appearance, the director and the beneficiary of the legal name of Marcus Campbell.
Are you Marcus Campbell or not?
I am.
All right. Where are we on this file, gentlemen?
Well, Your Honor, I filed a motion for summary disposition. I've received a notice from the court saying that this was a final settlement conference, but I was hoping that the court was going to take up my motion for summary disposition. I've not received an answer or any kind of a responsive pleading to my motion for summary disposition. There have been numerous filings by the defendant, virtually none of which I understand.
It's all right, Mr. McCardle. The defining trait of a nonsensical document is, well, the nonsense inside it. Nobody's going to fault you for failing to decode it when he clearly doesn't understand it, and the guy who sold him that fantasy paperwork definitely didn't understand it either. It's confusion passed down like a family heirloom.
So that's, as far as I'm aware, what the status of the case is.
Mr. Campbell, did you receive his motion for summary disposition?
I have sent a brief. I sent a brief to the courts.
Sir, are you listening to me?
Did you hear what I just said?
No.
I just answered. I sent the brief.
I asked you if you received his motion for summary disposition.
Yes, I have.
Okay. So then I'll just calendar it. That's all. Is there anything else outstanding?
Not that I'm aware, Your Honor.
Anything else outstanding, Mr. Campbell?
Yes, I do have something.
What
I did respond. I did respond to the courts and to the complainants.
Okay.
But before this matter go any further, I would expect 21 days and a provided proof of claim of evidence of the legal and lawful authority of the public to bring this to me.
So you're asking for discovery, but you do realize that requires a properly filed and properly served motion, right? Meaning you're actually expected to follow real procedure. So you might want to save at least one of your breakfast crayons to draft it, because that's the only way this request is getting off the ground.
Okay. Sir, you can file whatever motion you want. Right now, I'm going to calendar Mr. McCardle's motion for summary disposition. That if you say you filed an answer to it, we'll be prepared to go forward then. The motion for summary disposition, gentlemen, will be heard April 10 at 11 o'clock. We are going to call file number 22-186783, JP Morgan Chase versus Marcus Campbell, date and time for a motion for summary disposition. Could I have your appearances?
Of course, Your Honor. Jim McCardle appearing on behalf of JP Morgan Chase.
Bar number?
82443.
And your name, sir?
Marcus Campbell in special appearance.
Mr. McCardle, this is your motion.
Yes, Your Honor. Your Honor, we had issued demand to the defendant on March 15th of 2022. Receiving no answer, we then filed suit against the defendant on May 13th of 2022. Proof of service was finally obtained on September 26th of 2022. The answer was filed on November 14th of 22, and then we subsequently filed our motion for summary disposition on 12/15/2022.
Damn. This mess has been dragging on since May of 2022. If sovereign citizens can brag about anything at all, it's their ability to turn a simple court case into a marathon. They stall, delay, and stretch the process like it's their signature talent. But none of it makes a difference because no matter how long they drag it out, they still manage to lose every single time.
A series of responses, as it were filed, the last of which is a response to plaintiff's counter-defendant's motion to strike, in which the defendant has a number of things, but the chief among them In paragraphs 5 and 6, the defendant agrees with our motion, the allegations in our motion, that he's in default, and that there is currently due and owing a balance of $18,610.79. And then in paragraph 8 in our motion says defendant's answer fails to refute the obligation of the plaintiff. The response is defendant counter plaintiff agrees. However, defendant counter plaintiff's pleadings are not redundant, immaterial, impertinent, scandalous, or indecent in manner. So I'm not sure what that's supposed to mean. The upshot of this is, Judge. Oh, there's one other thing. Yeah, he suggests in his paragraph 1E that my client is practicing law without a license. Well, we're here on behalf of our clients, so my client corporation is not acting without an attorney, so that's irrelevant. So basically, what I'm asking for is judgment in the amount of $18,610.79. In essence, because the defendant has agreed that he owes the money.
Yeah, I'm starting to see a pattern here. The last sovereign citizen also accidentally admitted to owing the exact debt they spent the whole time claiming they never contracted for. I guess that's what happens when your entire legal strategy comes straight out of pro se for dummies. You end up proving the other side's case without even realizing it.
Mr. Campbell, your response?
I disagree, and I'll stand on my brief.
And you stand on your pleadings? Okay.
Which was
All right, the court's prepared to move forward in this matter. This is a motion for summary disposition filed on behalf of plaintiff and notice for hearing today. Plaintiff's motion for summary disposition was filed on December 15th, 2022. Following that date, the court register of action does not appear that any pleadings were filed by the defendant. Michigan Court Rule 2.116G4 is relevant here. A motion under sub-rule C10 must specifically identify the issues as to which a moving party believes there is no genuine issue as to any material fact. When a motion under sub-rule C10 is made and supported as provided in this rule, an adverse party may not rest upon the mere allegations or denials of his pleadings, but must, by affidavits or otherwise provided in this rule, set forth specific facts showing that there is a genuine issue for trial. If the adverse party does not so respond, judgment, if appropriate, shall be entered against him or her. No response was filed to the plaintiff's motion for summary disposition. However, in his earlier pleading, which is really not relevant because they were not, again, filed in response here, the defendant admitted that he owed the money. So that's going to be it. Court finds there is no genuine issue of material fact. Plaintiff is entitled to summary disposition as prayed for under MCR 2.116C10. Mr. Campbell, you have an absolute right to appeal my decision. That appeal must be perfected in 21 days today in the Wayne County Circuit Court.
Well, at least you nailed the special part. That much I'll give you.
We are on the record. We're calling file number 22198-398. The file is entitled Portfolio Recovery Associates versus Marcus Campbell. Your appearances.
Yes, good morning, Your Honor. Michael Kirshenheiter for the plaintiff, P75722.
And what is your name, sir?
Marcus Jamel Campbell in special appearance for.
In special appearance for what, sir? You filed an answer here. All right.
Jamel Campbell, special appearance.
I can almost guarantee his brief memorandum of law was submitted on something that still had dried saliva on it. And sure, a memorandum can be used to answer a motion for summary disposition if it actually outlines that jurisdiction's requirements, explains why summary disposition doesn't apply, and backs it up with real case law, statutes, and legal authority. If he manages to pull that off correctly, I'll need someone to check my pulse.
Mr. Kirshenheiter has filed a motion for summary disposition. Did you receive that motion, Mr. Campbell?
I'm not sure if I have, but I'm wondering if you all have my paperwork. I'm not sure if I did.
I have a motion filed by Mr. Campbell. My question is, did Mr. Kirshenheiter, did you receive his motion?
I perceive so.
Okay, so you got the motion for summary disposition filed by the plaintiff. Mr. Kirschenheiter, did you get the motion filed by the defendant?
Your Honor, I'm not exactly sure what we received. It just says brief and memorandum of law.
Yep. Okay, that's fine. We have that. Now, Mr.
Yes.
Campbell, my question
Yes,
to you is that your answer to the motion for summary disposition?
Yes, it is.
That is your answer.
Right.
Forthwith is just the judge's professional way of saying, "Sir, you have no idea what you're talking about." It's the courtroom equivalent of calling him a complete fool, just wrapped in legal vocabulary. And hey, at least this means I won't be forced to eat any spotted dick today.
Okay, so then neither side wants any discovery, and all I need to do is calendar your motion. Is that what you're both telling me?
Yes, as long as it,
Okay, here's what we'll do. The court will calendar for May 1st at 11 o'clock, plaintiff's motion for summary disposition. We will receive Mr. Campbell's pleadings denominated brief and memorandum of law and proof of service as the answer to that motion. This is 22-198-398, Portfolio Recovery Associates versus Marcus Campbell. Date and time for a motion for summary disposition. Could I have your appearance?
Good morning, Your Honor. Jeff Werber, P67124 on behalf of the plaintiff.
And what is your name, sir?
Marcus Campbell in special appearance.
Mr. Werber.
Yes, Your Honor. Today's the date and time set for plaintiff's motion for summary disposition pursuant to MCR 2.116C9 and C10. This was a Care credit card issued by Synchrony Bank. It was opened up on November 29, 2018. As the invoices attached to the motion reflect, the last payment made on this account was June 30th, 2021. At the time of charge-off, it left a balance of $3,171.94, the exact amount the plaintiff filed the lawsuit for. Those monthly invoices were all mailed to the defendant at his current address, which he placed on his answer and his response to the motion for summary disposition. Defendant made payments on this account for almost 3 years and has not shown that he ever objected to those monthly invoices that he received in the mail. He filed a general denial answer and a lengthy response to plaintiff's motion, but neither provide this court with a genuine issue of material fact or a true defense to this motion. So plaintiff requests that the court grants its motion for summary disposition today.
Mr. Campbell.
Yes.
Your response, sir.
I sent a brief regarding the denial.
Yes, the court has had the opportunity to read your brief, and I thought it was an interesting set of matters that you set forth here.
He's 0 for 2 so far, and honestly, I'm rooting for that classic third time's the charm. At least for those of us watching this train wreck of a litigant crash through another case. All right, moving on. This is case number.
Prepared to rule on this matter. Is there anything else you want to say in addition to what was filed?
Right. I have not contracted with them, and I do not wish to contract with them now. I just want to make sure that the brief is on the record, though.
I see your brief and memorandum of law and proof of service.
Yeah. So all of that is on the record.
I see it's filed here, and I see
yes, sir. That's all I know.
I know, for example, that you cite federal rules of civil procedure. I
Right.
know, for example, that you cite 28 USC 2403. I further note you cite MCR 2.614. Okay, I'm prepared to rule.
Yeah.
Having had an opportunity to read the pleadings both by Mr. Werber and by Mr. Campbell, the court is satisfied that there is no genuine issue of material fact. The motion for summary disposition under MCR 2.116 C10 will be granted. I'll send you gentlemen out of order. Did you attach an order, Mr. Werber?
Yes, Your Honor. There is an order attached to plaintiff's motion. It's right before all the exhibits.
I see it. I see it. All right, the
Right.
court will enter that today. Mr. Campbell, you have an absolute right to appeal my decision. That appeal must be perfected within 21 days of today in the Wayne County Circuit Court.
So let me get this straight. You're demanding they pay your fee schedule for trying to recover the money you took and never paid back? That's next-level delusion. You should honestly be grateful society hasn't slapped you with a fee schedule for wasting everyone's oxygen, because you'd be in debt for the rest of your natural life.
Case number 22196913. This is Capital One versus Marcus Campbell. The matter is before the court set for a status and scheduling conference, and I'm looking for Marcus Campbell. If you're on the Zoom, please say something at this time.
Yeah, Marcus Campbell and special appearance.
All right, thank you, Mr. Campbell. All right, today is the date and time set for a scheduling conference regarding this matter. It appears that this is a complaint wherein the plaintiff claims that there is a total amount of $1,874.21 that's owed as a result of a Capital One bank account in this matter. All right, and I received an answer that was filed in this regard, and it appears that the answer is a general denial of any claim of obligation regarding the indebtedness. Counsel, has there been any opportunity for the parties to talk about whether or not this matter could be resolved?
Your Honor, I've not spoken with Mr. Campbell today. Based on some documents that he filed and sent to our office, I don't believe it will be helpful to speak as far as getting it resolved. My office will be filing a motion for summary disposition.
Right. Anything you wish to say at this time, Mr. Campbell, regarding whether or not there is a prospect of resolution in this matter, sir?
No, sir. I just want to be sure that my proof of service, my brief, and my fee schedule is on the record.
So on June 13th, he gets one final shot to prove he's got even a couple ripples in that brain of his, one moment to show the world he's not a certified grade A loser. And what does he do? He blows it completely and doesn't even show up. That's his whole pattern in one sentence. Given a chance to succeed, he still manages to fail at attendance.
All right. What I've received, and I've received your answer to the complaint in this matter, as I've indicated previously. That was filed with the court on March the 10th, and that answer sets forth a 23 count response, and then it sets forth affirmative defenses items 1 through 9. That's what the court has received. All right, I am going to set this up on a schedule, allowing the parties to engage in the practice of discovery, that is to request any information that you may need from the opposing party in writing, and that information will be turned over. This process also allows for the submission of interrogatory sets of questions. It allows for requests to admit and other items of discovery that may be allowed under the court rules. Accordingly, I'm going to put this on a 60-day schedule with the return date in this matter set for the 13th of June, 6/13/23.
Oh, for 3. Impressive. Congratulations. You've officially earned yourself the Donkey of the Day award. Anyway, guys, that wraps up the video. I'm leaving Bratislava today and heading to Vienna next, where you'll be getting another video from me. If you enjoyed this one, hit like. If you didn't, hit dislike. Engagement is engagement. Drop a comment below, and make sure you're subscribed with notifications on so you don't miss any of my content.
The defendant in this matter, Marcus Campbell, or anyone representing Mr. Campbell, if you're on the Zoom, please say something at this time. The matter is set on for 9:30 a.m. It is now approximately 9:39. Let me ask you, counsel, have you had any contact with Mr. Campbell? Any response to the motion for summary disposition? Update me on any information that you may have at this time.
No, Your Honor, no response to the motion and no contact from defendant.
Defendants failed to appear. Moreover, in reading the motion and the issues raised thereby, as well as the predicate and history of this these particular transactions herein, I don't see that there is a genuine issue of material fact in this matter, and that defendant, I have to conclude that the plaintiff is entitled to judgment as a matter of law. Moreover, I do not see where a defendant has raised a valid defense to the claim. And so the motion for summary disposition will be granted at this time.